Hello, everyone. My name's Stephen Wood. I'm the director of the Center for Law and the Environment at the University of British Columbia, coming to you as an uninvited guest on the unceded and occupied territories of the Musqueam, Squamish, and Tsleil-Waututh peoples. I'd like to welcome you to the third webinar in the series, In Their Own Words, Plaintiffs and Their Lawyers Speak About Youth Climate Cases. Today, we're turning our attention from Canada to the United States. The last two of our webinars will deal with two of the leading youth climate cases before the courts in the United States. Today, it's held against the state of Montana. And this is really a landmark case because it is the first climate change case in the world, I believe, to be decided after a full trial with witnesses and cross-examination, and it was a resounding victory for the youth plaintiffs in the case. 16 youths in Montana went to court challenging their state and its actions on climate change as violating their constitutional rights, including rights to equal protection, dignity, liberty, health, and safety, and the public trust, which are all predicated on the right to a clean and healthful environment. So the court invalidated as unconstitutional Montana laws that promote fossil fuels and require the state to turn a blind eye to the climate change impacts of fossil fuel extraction and development. The court also ruled that the plaintiffs had proven their standing to bring the case by showing significant injuries, the government's substantial role in causing them, and that a judgment in their favor would change the government's conduct. So the decision was the first of its kind in the US and I believe in the world, and it's considered to set a crucial evidentiary and legal precedent for the right of youth to a safe climate. Today we're joined online by one of the youth plaintiffs, Claire Vlasis, and one of her attorneys, Nate Bellinger. I'll introduce Claire briefly. Claire can only be with us for half an hour, and so we will actually open for questions for Claire before she has to go. And so I'll just very briefly read Claire's bio. Since middle school, Claire has been taking action to address the climate crisis. She started a solar club and raised enough money to install solar panels on the roof of her school. However, due to a cap on solar power in the state's law, she was not able to run, the school is not able to run solely on renewable energy. It was at that young age that Claire had her first experience with how her state government was impeding climate solutions. Growing up in Bozeman, her favorite activities have always been outdoors: skiing, biking, running, and hiking. Seasonally, she works as a ski instructor at a ski resort, but due to decreasing snowpack, her shifts are often canceled, negatively impacting her ability to work and make money. Declining snowpack and drought conditions also reduce water flow through Bozeman Creek, which is the main water source for her family and their garden. Claire, thank you so much for joining us. It's an honor to have you speak, and I will hand the mic over to you now.
Thank you for having me. And thank you to all that are tuning in and listening. Yeah, I've been experiencing climate change throughout my entire life. I grew up on a small farm in Montana, and I've always had a huge love for the land and want to do everything I can to protect it. And so when I realized that climate change was impacting that land, my home, my community, I wanted to do something about it. And so, like Dr. Wood said, I started raising money for solar panels when I was in middle school. And from then, I just started really caring about environmental action, and I got to help plan the sustainable development for my city, and then later joined this lawsuit. So, yeah, over the course of the past few years, I've really come to recognize climate change impacting my community. So there's a river that flows through my property and we have water rights to it. And as the river flows and ebbs throughout the season, that has been a big indicator of climate change impacting my home. And I wanted to actually, take action with it. So I decided to join the lawsuit when I was 16 or 17, I think. And for the past few years, have been working on making that happen. And then this past June, we actually were the first case of this kind to win. So, um, yeah, the Judge Seeley, ruled in a 103-page ruling that climate change um, is indeed impacting us as young people, and that our state government has been promoting fossil fuels unconstitutionally. So that's been a really big win for us. Yeah, in that case, we outlined the ways that our government has been contributing to climate change. For example, back in the 1960s, we started, our government started recognizing that climate change has been impacting the state and that fossil fuels were a main contributor of climate change. And then for decades, the state continued to promote fossil fuel industries, to grant permits, and to continue with coal excavation, which all were knowing impacts of climate change. And so anyway, now with this lawsuit, our government needs to have environmental reviews. It needs to have recognition that there is indeed an impact, a consequence of the decision making, and that environment needs to be considered in all governmental decision making. I decided to sue the government because I was only 16 at the time, so I couldn't vote. And I know we have three branches of government for a reason. And I believe that it's important to hold my government accountable when our rights, especially as young people, are being violated. So through this litigation, I've been hoping to accomplish meaningful change. And I think so far we have been doing that. I guess as a plaintiff, I was really nervous during depositions and when taking the stand at trial, but I knew that what I had to say was my truth. And so speaking on something that is so true and so near and dear to my heart took all of that fear away. Yeah, those are my main thoughts right now. Let me know if any of you guys have any questions about my journey with that. And thank you for having me.
Claire, thank you so much. I will open up to questions, but I have a question myself, if you don't mind. What was it like? So you talked about giving a deposition and giving testimony at the trial. Can you give us a sense of what that was like? I watched Ricky Held testify on the live stream. I couldn't watch the whole trial, but it was just so powerful, and she was so courageous and articulate on the stand. What was it like for you? How was that experience?
Um, yeah, like Ricky, I think it was a really emotional experience for me and for all of the plaintiffs. Um, Especially because climate change seems like almost an abstract experience. It's hard to put into words, really what has been impacting you. And so, I was nervous about talking about something that only I feel like really experts can testify to, like how climate change is actually happening. But I recognize climate change related events in my own life, like how I mentioned the river flowing through my property. And then also I work as a ski instructor in the winters, and there's a lot of times where I've been called off of work or ski season has started later, weeks later even, from its original date because there's not enough snow. And so instances like that are clear indicators to me that climate change has been impacting my life. And when talking about those experiences on the stand and during depositions, it definitely was nerve-wracking, just to feel questioned in your own truth and values and experiences. But again, holding to that truth, I think, is a really powerful thing, knowing that what you have to say is real and that people are forced to listen. That really is validating.
Maybe, and then turning in the other direction, so you sort of were talking about your experience giving testimony and having that impact. What kind of impact has the lawsuit had on your life? Like, how does it affect your daily life? Has it had any impact on the sorts of decisions you're making about where you'll go in life? What sort of things you might study or do?
Yeah, that's a great question. Um, at the beginning, my parents, I told them about this lawsuit because it had um passed across my desk when I was working in climate activism as a young person. Um, and I told them about it and asked them what they thought about me joining the lawsuit, and both of them told me that it was probably something I should not do. They work in public spheres. My dad works for our nonprofit hospital, and my mom actually works for the state of Montana. So they both are very not political when it comes to their jobs, and they didn't want me to go down a path where I would be making very public my political opinions. But I thought about it more and I realized that for me, caring about the environment and the land is not a political issue. I think it transcends the politics that divide us as a country. And that's another reason why this lawsuit I think is so powerful, is because it shows that protecting the constitutional rights of people, especially young people, I think, um, isn't something that can be politicized. And I think that a care about caring about the land and community that you're from, it really shouldn't be something that's like a political issue either. And so those were my main hesitations when beginning the lawsuit, just worrying that people would get the wrong impression about where I stand with my ideology. But yeah, since then, I think it has impacted a lot of my daily life. I've gotten more experience getting to talk to people, especially people that don't always agree with me, um, and hearing from a lot of people about their experiences with climate change and how real it is for a lot of people um, in their day-to-day life. And I think now I'm a computer science major. I'm a junior in college. I plan on using that tool of being able to code and build stuff online um, for the intersection of sustainable development and agriculture. So I think that has really impacted my journey and where I'm going to go next.
That's great. I'm just going to see if there's any questions here in the room. Okay, so there is one, but before you start, I'll just mention that there are microphones in the room. You see them on the desk in front of you. If you press the button, just wait for it to turn solid red and then go ahead.
I was wondering how you substantiated your argument that the government is not in the line with the constitutional duty for the future generation. What did you claim to prove it?
Yeah, thank you for your question. I think so in trial, I talked about my own experiences with um changing environments around me. So like water flow, like snow melt, even wildfires and smoke being big impacts to my own life. And that was accompanied with expert testimony from certified experts that the court allowed, which they spoke on the scientific backing of climate change impacting snowmelt and river flow and wildfires and smokes and stuff like that. So although, just as someone who's not an expert in that, I can't speak on climate change being a direct cause of that, but the experts did. And I think the testimony of my experience tied with that was proof to the court that climate change is real, happening, and affecting the lives of the plaintiffs. And then it was tied also with the actions of our government, acknowledging that they know that climate change is happening, they know that fossil fuels is linked to it, and continuing to support fossil fuel industries unconstitutionally.
And I'm sure we'll hear more on that subject from Nate when he speaks. But another, I think, really important thing that you were able to convince the court was that every ton of GHG emissions matters. Every emission causes harm. So the state can't say, oh, well, we're too small to make a difference, right? Yeah. Is there another question in the room? How about online? It's a quiet crowd.
Can I
Yes, please go
ask
ahead.
you a question, Claire?
Yeah.
The case, as you know very well, the case got a lot of attention in the media, and you've had a lot of opportunities to speak to national press and give presentations, probably more than you anticipated going into this. And I'm just wondering what that experience has been like to not just in the courtroom, an actual trial, but kind of have all those extra opportunities and experiences outside the courtroom, giving presentations like this, speaking to the media. Claire accepted and at the Time Earth Award recently in New York City. So lots of opportunities like that. So what's that like?
Thanks, Nate. Yeah, I think that is a really big aspect of how this trial has impacted me. I have had lots of opportunities to speak to people and nationally and internationally about this case, and that I think really goes to show how important this decision is. Not only is it the first of its kind, a legal precedent for all of these cases that are happening across the country and the world, but it's also an opportunity to actually speak up about what is going on and how climate change is impacting young people for real. I think as a young person, it's easy to feel helpless with climate change because it is such a planetary issue. It's so big. But this case shows that, change is actually going to happen, and that we are finally being heard in the courts and on the media. And so having the chance to speak at anything, even speaking to you guys is a great opportunity to share my story and share what is going on and how big it is. And just, it means a lot to know that things are actually happening and that it's time to listen.
We may have a question in the webinar. Someone had raised their hand and we've just let everybody in the webinar know. If you've got a question, use the Q&A function. I forgot to say that at the beginning. It's in the toolbar that you usually have at the bottom of your Zoom screen. So Claire, yeah, you talked about this feeling of hopelessness, but you sound like you're feeling rather hopeful. So how are you feeling about the future for the climate?
Yeah, thanks. I think I do have a really optimistic perspective. Just because I believe that anyone can make a difference about it. And like what you were saying earlier, I mean, every bit of carbon dioxide and emissions that go into our atmosphere, it makes a difference. And so with that knowledge, it's inspiring, I think, to be aware of your own actions and the consequences that it has for our environment and for everyone. And so I believe that everyone has a capacity to act on issues that matter to them and pursue stuff like that. And I know we all have different capacities for which we can dedicate to actually making change and pursuing our passions, but I believe that if everyone took time to do something like that, whether it be really small, like posting on an Instagram story, or really big, like suing your government and winning, I think that all of that contributes to the greater good. And so I'm hopeful that other people like me can see that what we do really matters, big or small, and it all contributes to the overall well-being of our society.
Thanks. Inspiring words. And I believe there is a question. So Kylie's going to read it out.
There we go. Yeah, so we have a question from online. This is from Lindsay. And it's a bit of a specific question, but maybe you could also just speak generally to kind of collaborations that you guys do. The specific question is, Claire, are you available to speak over Zoom to youth who are trying to get a green amendment in New Jersey passed related to constitutional right to clean air, pure water, healthy ecological habitats, and a stable climate? So that's the specific question. So maybe if you could speak to that, and maybe just other collaboration that you guys do.
That's great. I'm so glad to whoever wrote that, that those young people are going through that and actually, working on something like that. I think that's great. I would love to speak to them. I need them to get in contact with their media team at Our Children's Trust. So that would probably be the first step.
And it's probably worth noting that Montana does have a constitutional right to a healthy environment. And I guess you probably found that helped basically in your case.
Yeah. So one thing that Montana has that I think is really special to the state is a right to a clean and healthful environment as outlined in our Constitution, which I think was a really big thing, but it wasn't the only right that really mattered for this case. And I think the judge's decision made clear that our right to life, liberty, the special rights that are in the Constitution for young people in specific, rights like those, which are in, nearly all constitutions in state constitutions in the US and even constitutions around the world, those too have been violated by promoting fossil fuels and not considering the environment in government actions.
Yeah, thanks for pointing that out. That's really important. I think it's probably time for us to let you go now. It's coming up to your deadline imminently. So I'd like to thank you once again for joining us and sharing your experiences and your courage and your inspiration with everybody. So I'm just going to ask people in the room to join me in a round of applause that I hope you'll be able to hear over the microphone. Thank you.
Thank you for the time. I appreciate it.
Thank you.
Bye.
Bye. And so now I will introduce our second speaker, Nate Bellinger. who's one of the attorneys for the youth plaintiffs in this case. Nate earned a Bachelor of Science from UMass before moving to Oregon. After spending 3 years working as a firefighter, ski instructor, there's a bit of a common theme here, and rafting guide, Nate returned to school and earned a master's in geography from University of Oregon. His thesis documented the social and environmental impacts of Ecuador's commercial tuna fishing industry. Interestingly, Ecuador is another place where there's a right to a healthy environment and also rights of nature in their constitution. Nate then decided to pursue a law degree to develop an additional skill set to fight for solutions to the multitude of injustices in the world, and in 2014 graduated from the University of Oregon School of Law. As a senior staff attorney at Our Children's Trust, Nate works to protect the constitutional rights of youth to a stable climate system and advocates for science-based solutions to the climate crisis. His scholarship has been published in the American Bar Association magazine, Natural Resources and Environment, and the Wake Forest Journal of Law and Policy. When not working, you can find Nate working in his garden, running in the woods, or exploring the Pacific Northwest's magnificent lakes and forests with his family. Thank you for that great bio sketch, Nate, and thanks for joining us. Congratulations on the win, and over to you.
Well, thank you for having me and Claire here to talk about Held v. Montana today. I'm really glad you got to hear from Claire to kick things off, and I will try not to kind of repeat much of what Claire said, but kind of tie in some of the legal arguments and get into some of the expert testimony that we presented at trial. I'm going to share my screen. Can you all see that?
Yep, we've got that. Thanks, Nate.
Okay, great. So before I get into the details of Held, just briefly, I wanted to introduce Our Children's Trust, what we do. We're a public interest law firm, and we exclusively represent youth in climate litigation cases, and we've been doing that since 2010. There's 3 principles that really guide all of the work we do and all of the cases that we bring. And the first is that we're advocating on behalf of diverse youth and future generations for climate rights. So all of the cases we bring are on behalf of youth clients. And we're advocating for science-based and legally enforceable systemic remedies against governments in court. So Held was really exciting because we got to bring a lot of science into the courtroom. So that was a really important part of the work that we do. And then all of our cases are based on protecting fundamental human rights, like constitutional rights. And part of the reason why that's important is because our goal is to secure durable and lasting solutions and remedies to the climate crisis that can't just be undone by changes in administrations or legislative acts. So the Held v. State of Montana case was filed in March of 2020, and it took us a little over 3 years, but we got to trial last June, June 2023, and we had a 7-day trial in Helena, Montana. And I'm not going to go into all of everything that happened during those 3 years. It'll take a long time, but just suffice it to say the state of Montana spent a long time, a lot of effort trying to prevent the case from going to trial. There was extensive motions practice. They went up to the Montana Supreme Court twice to try and get the Supreme Court to intervene and block the trial. So they spent a lot of time trying to avoid trial, really right up until the trial began. And we also engaged in very extensive discovery during that time period as well, exchanging expert reports. We did about 36 depositions. The plaintiffs were deposed, experts. We deposed witnesses for the state. and tens of thousands of pages of documents were exchanged. So it was a busy 3 years, but it was a really exciting moment to finally get to trial last summer. And here you can see just little pictures of each of the plaintiffs, the 16 plaintiffs from across Montana. It's just a really, really inspiring and remarkable group of youth, as I'm sure you noticed with Claire. They're all really, really incredible plaintiffs. So just touching a little bit more detail on what the case is about, what we're challenging. The case is really a challenge to Montana's laws and conduct that promote and perpetuate the state's fossil fuel-based energy system. And we challenged 2 specific statutes when the case was filed. And the first one is a provision of the Montana State Energy Policy, which has specific provisions that call for the state to increase the use and development of the state's fossil fuel resources. And the second law we challenged is a provision of the Montana Environmental Policy Act, or MEPA. And that MEPA requires the state agencies to conduct environmental reviews before issuing permits for various projects, including fossil fuel activities. And the provision in MEPA that we challenged, known as what we've called the MEPA limitation, prohibits the state from considering greenhouse gas emissions or climate impacts when making permitting decisions. So you really had these laws working together to, on the one hand, call for the state to increase the use and development of fossil fuels, and at the same time make it illegal for the state to consider how those fossil fuel projects are contributing to climate change, harming Montana's environment and citizens. And this, as we heard a little bit, the case is based on Montana's constitutional rights. Montana's constitution it's a really remarkable constitution, great rights secured, including the right to a clean and healthful environment, the right to individual dignity and equal protection, the right to safety, health, life, liberty, and property. And all of these rights are fundamental rights in Article 2. And that means that any conduct that implicates those rights is subject to strict scrutiny. The Constitution also has explicit protections for youth or those under the age of 18 in Article 2, Section 15. And in the preamble also mentions, protecting the rights for present and future generations. And the other thing that's unique or, compelling about the Constitution is there is a very extensive constitutional convention history from 1972 when the Constitution was amended. And the transcripts from that are often cited by the courts in Montana. And those transcripts really reveal that the delegates were enacting and drafting a constitution that was intended to protect, future generations, protect children, and the right to a clean, healthful environment. It was a really important part of that and extensively discussed in those records. So once we finally got to trial, as you've heard, Claire and other plaintiffs ended up having the opportunity to actually take the stand and testify in court. We ended up with 12 of the 16 plaintiffs testifying, and a guardian for 2 of the other plaintiffs testified. And it was the first time that youth had an opportunity to take the stand in a court of law and really explain for the court, for their own government, for onlookers, how they were being harmed by climate change and how those harms were impacting them today. Climate change isn't some distant threat. They're experiencing real harms today. As you heard from Claire, I think her experience was similar for a lot of the other plaintiffs. It was was a nerve-wracking experience for a lot of them. They were nervous going in, but I think, you know, a lot of them talked about how once they got up there, they settled in and they realized they're just telling their story, their truth, their own experiences. And I think it was a very, very empowering and rewarding experience at the end of the day for all of them. And we also had expert testimony from 10 different experts. And these are, you know, really the best experts in their respective fields. And I'm just going to take a couple minutes to walk through at a high level their testimony, because it really informs the order that we secured from the district court, and, you know, I think gets at some of the questions that were raised about causation and injury and standing and things like that. So starting in the top left, we have Dr. Steve Running, and he's a Nobel Prize winning climate scientist who testified about the physics of climate change, you know, how it works, and the need to restore Earth's energy balance, the dangerous amount of greenhouse gases that are already in the atmosphere. And a lot of that basic climate science was disputed by the state going, you know, leading up to trial. So we really had to start, you know, at square one, which was, you know, an exciting opportunity to be able to put all that climate science, present all that science in the courtroom. And then we have Dr. Kathy Whitlock, who is another climate scientist, and she detailed the ways in which climate change is impacting Montana's environment. And so increasing temperatures, changing precipitation patterns, increasing wildfires, droughts, declining snowpack and things like that, and really brought home the impacts to what's happening in Montana. And then next is Dr. Jack Stanford, who's an expert in freshwater ecology. And he testified about the impacts of climate change on Montana's rivers and lakes and aquatic ecosystems. And then we have Dr. Lori Byron, who is a pediatrician, and she provided expert testimony to support a lot of the plaintiffs' allegations related to their health impacts. So she explained the dangers of wildfire smoke, for example, for children. And what was important about her testimony too was really elaborating and explaining on how these plaintiffs as children and youth are disproportionately harmed by greenhouse gas pollution and climate change because their bodies are still growing and developing, and by virtue of the fact that, you know, they have a lot longer to live with these extreme climate impacts. So that's what she testified about. Then we have Mr. Mike Derglow, who's the chairman for the Climate Change Advisory Committee for the Confederated Salish and Kootenai tribes. And he testified about the unique ways in which climate change is impacting tribal traditions and cultures, making it harder to access, you know, certain food sources and traditional medicines. And then moving down to the bottom left, Dr. Dan Faegre is a glaciologist, and he has studied Glacier National Park for about 3 decades and described the decline of glaciers there as a result of climate change, and explained that, you know, without significant reductions in greenhouse gas emissions, all of the glaciers will be lost within the plaintiffs' lifetimes. And then Miss Ann Hedges is a policy expert in Montana. So, you know, Claire mentioned the state's knowledge of climate change, and this is where, you know, Ann Hedges brought that testimony in about how, you know, the state of Montana has known that climate change and fossil fuels are dangerous for decades. But despite that knowledge, she testified she's never seen the state deny a permit for fossil fuel activities. And instead, they're actually, you know, encouraging and promoting fossil fuels. And then in the middle, Mr. Pete Erickson, a really important part of our causation story. He quantified all of the fossil fuels that Montana is responsible for extracting, burning, and transporting through the state, and the greenhouse gas emissions that result from all of those fossil fuels. And he compared those to other countries around the world to show that the greenhouse gas emissions that Montana is responsible for are nationally and globally significant emissions. And the state has a lot of fossil fuel reserves that they intend to continue to extract and burn, if we don't get a ruling telling them that that's unconstitutional. And then Mr. Mark Jacobson, or Dr. Mark Jacobson, is an engineering expert at Stanford, and he described how the state of Montana can meet all of its present and future energy needs by transitioning away from fossil fuels towards 100% renewable energy, and that transition can be accomplished as soon as 2035 and no later than 2050. And then finally, we had Dr. Lisa Van Susteren, who's a psychiatrist, and she provided expert testimony to support the plaintiffs' mental health injuries and mental health harms, which was something that a lot of plaintiffs talked about. And Dr. Van Susteren explained how that's consistent with a lot of the literature she's seeing about how experiencing climate impacts and extreme weather events can result in mental health harms. But she also brought in another layer of mental health impacts that comes from when your government, which is supposed to be protecting you, is affirmatively taking steps to harm you, and when they know what they're doing is going to harm you. And that's a concept that she called institutional betrayal. So all of these experts, together, they presented the scientific evidence and the causation evidence and the redressability evidence to support the legal claims and all of the plaintiffs' individual testimony about how they're being harmed by climate change. And what's important, give them all a shout out, they all volunteered their time to serve as experts in this case. And so they're all serving pro bono, which is incredibly valuable and would have otherwise cost a lot of money and almost probably have been prohibitively expensive. So really, really incredible service that they provide to the plaintiffs. The state, so we presented our case for a week, and then the state had a week to present their defense. They took about 3 hours to do so. That's all they could muster. They had three witnesses. 2 of them were employees for the Department of Environmental Quality, and they offered no factual defense for anything they were doing. And instead, they basically said, we're just a state agency. We do what the legislature tells us to do, and actually took a position that they didn't have the authority to deny permits. So this is a really important part of the trial testimony, that we got them to admit that it's their position that they're required to approve permits, even if it would result in the infringement of constitutional rights. So getting them to say that on the stand was really important, because then we were able to have the district court correct their misunderstanding of their duty to approve all fossil fuel permits. And then they had one expert testify, an economist, who intended to show that Montana's greenhouse gas emissions are small in consideration or comparison to global emissions, but his testimony was riddled with errors and ultimately given no weight by the district court. And then I just want to add here too that there was another expert that the state had identified prior to trial, who submitted an expert report, and we deposed, who was a climate denier. And the state ended up not calling her to testify at trial. And I think that decision really underscores the importance of having cases like this go to trial, having the scientific evidence come out in court where there are rules of evidence. And I think the state realized that if they tried to put a climate denier on the stand, it would just not, it wouldn't have held up, especially subject to cross-examination in comparison to the experts that we put on who were, the best in their fields. So they ended up not putting on that expert and offered no evidence to contradict any of our experts or our plaintiff's testimony. So all of that testimony was uncontradicted. And maybe not surprisingly, because they basically didn't put on a case, we won. In August, a couple months after trial, we secured a really, really historic decision. Just an overwhelmingly positive decision where we won on all aspects of the case, and really important findings of fact and conclusions of law that I just spent a few minutes running through. As one expert at Columbia said, I think this is the strongest decision on climate change ever issued by any court. So really, really historic and exciting victory. And the decision contained nearly 300 findings of fact. As I think Claire said, it's a long order, it's 103 pages. So there's a lot in there. And the court went through the expert testimony and issued these findings of fact. And one of them was about the Earth's energy balance and how there is a significant Earth energy imbalance that's causing climate warming and the various climate impacts as a result of the concentration of CO2 in the atmosphere of about 422 parts per million. And noting that in order to restore Earth's energy balance so we don't have continued warming, the CO2 concentration needs to get back to 350 parts per million. And this graph actually made it into the district court's order. The opinion also, the 100+ page opinion, and 20 pages of that opinion was spent detailing the harms to each of the plaintiffs. And I think for the plaintiffs, this was really meaningful and impactful because, they put themselves out there. They made themselves vulnerable. They were testifying, for the first time in a case like this, taking the stand, telling really personal stories, really emotional stories about their own vulnerabilities and climate injuries, and against a government that was very hostile towards them. And to have the court hear them and recognize their injuries and their impacts was really significant, and I think really impactful for the plaintiffs. And so here you can see Ricky held, and she described impacts as a result of climate change to her ranch in eastern Montana, and how hard it's been to, she's been forced to work on the ranch as you have to do, regardless of the, smoke-filled skies or 110-degree heat, and described how that's been really harmful for her health. Other plaintiffs like Badge and Lander here talked a lot about how hunting and fishing is a really important part of their family traditions, family activities, and a means to provide food for the family. But as a result of drought and wildfires and declining river flows, warmer water temperatures, it's been harder for them to do that more recently. And a lot of the plaintiffs talked about the impacts of wildfire smoke, and these were also acknowledged by the district court's order. And the health impacts of the smoke are really harmful for all of the plaintiffs, but especially, 5 of the plaintiffs have pre-existing respiratory diseases like asthma, and it's especially dangerous for them. And Olivia, for example, described how it feels like she's suffocating when she goes outside in the smoke in the summer. And these plaintiffs had to adapt their activities and spend a lot more time inside than they would have otherwise have liked to. And the mental health impacts were also acknowledged by the court. which is something that a lot of the plaintiffs described experiencing. And for the plaintiffs the indigenous plaintiffs such as Sariel, Lillian, and Ruby, they also described how hard it is to have their tribal traditions and cultures being threatened by climate change. And Sariel described how there are certain creation stories that can only be told when there's snow on the ground, and with less snow on the ground, she's worried about the ability to pass on those creation stories going forward. So based on all of the evidence and the close to 300 factual findings, the court found that plaintiffs had established standing. The state had argued with respect to the injury prong of standing that the plaintiffs hadn't demonstrated they were uniquely impacted by climate change, and therefore they didn't have particularized injuries to establish the injury element of standing. And the court rejected that, finding that as children and youth, these plaintiffs have been disproportionately harmed by fossil fuel pollution and climate impacts. And then importantly, held that every additional ton of greenhouse gas emissions exacerbates these injuries and risks locking in irreversible climate impacts, really underscoring the sense of urgency here. And then the court also rejected the state's argument that Montana's emissions don't really matter, and found that their state's emissions do contribute to climate change and plaintiffs' injuries. And then relatedly, also found that a reduction in Montana's greenhouse gas emissions would at least partially redress plaintiffs' injuries. The state made arguments about how climate change is a global problem, and even a successful outcome in this case won't solve climate change. And there's some truth to that. Obviously, climate change is a global problem, but what's important is that Montana can help make the problem better going forward and minimize the harm to plaintiffs in the future. And then as to the constitutional claims, the court found that Montana's climate, environment, and natural resources are unconstitutionally degraded and depleted as a result of current levels of greenhouse gas emissions. So the current levels of greenhouse gas emissions being unconstitutional, and the holding that every additional ton of greenhouse gas emissions further harms plaintiffs, really means that the state cannot continue to take actions to increase their fossil fuel emissions, and instead needs to take steps to decarbonize its energy system and bring its conduct into constitutional compliance. And then the state declared unconstitutional and joined the MEPA limitation, and now that law is gone. So following the trial, just to kind of catch you up on where we are today, the state appealed the decision to the Montana Supreme Court, as we anticipated that they would. Their opening brief to the Montana Supreme Court is due next week, and then we will be filing our answer brief in March. While their appeal is being resolved by the Montana Supreme Court, they asked first the district court and then the Supreme Court to stay the district court's ruling, and both courts rejected the state's request to stay the ruling, and found that the state hadn't presented evidence that they're likely to succeed on the merits of their appeal or will be irreparably harmed absent a stay, and especially when you consider the ongoing injuries to plaintiffs. So that August 14th order, that's the law in Montana, and it's binding on defendants today while their appeal is being resolved. Next week, when the state files their brief, we're also going to see probably 6 or 7 amicus briefs being filed on behalf of the state as well, representing trade groups and business interests and utilities. So they're lining up to support the state and their appeal. And when I see that, it tells me we're doing the right thing if all those types of amici are weighing in. And yeah, once all the briefing is completed, we expect the Supreme Court to set an oral argument date, and should have a final decision by the end of the year. So keep your eyes out for that. And then just briefly, I'll say, I know you're going to hear later about Juliana. We also have a case in Hawaii that's going to trial this coming June, and another federal case, Genesis v. EPA, and other state cases. So lots going on, and you can follow all that action on our mailing list and website and social media and all that. And yeah, I'll leave it there.
Thanks so much, Nate. That was so informative and really exciting. Really took us through how important this case and the decision are. So we have time for questions. I'll take a quick look in the room to see. It does look like we have more than one question, so I don't need to exercise my chair's prerogative. I'll start over here, and the camera should come to you.
Yeah, thank you, Nate, for the talk and presentation and for the opportunity to ask questions. I'm wondering how difficult it was to prove before the court of law, both scientifically and legally, that some of the injuries that the plaintiffs suffered, for example, the mental health issues that you mentioned the plaintiffs suffered, were direct result of the government action or inaction of the legislation. So how were you able to prove that before the court of law, and how difficult it was?
Yeah, so the mental health injuries were actually some of the easier injuries actually to connect to the government, because as our psychiatrist expert testified, there's strong kind of connection between the plaintiffs kind of mental health injuries related to the state's kind of affirmative actions to betray their best interests. So when you have, as I mentioned, this concept of institutional betrayal, you have a government that's intended to be protecting you, and they are actively acting against your own best interest with full knowledge of what they're doing, of harming you. And that is, a lot of the plaintiffs described, feeling betrayed and hurt and harmed by the government's actions to do that. So that was relatively straightforward. With some of the other injuries, what we didn't need to prove that Montana's actions are the sole cause of the declining snowpack, for example, or the wildfires in Montana, but rather that their actions are contributing to the problem and making it worse. And that's actually not that hard to prove either right now, especially because you have, as I mentioned, you already have this dangerous level, this unconstitutional level of greenhouse gases in the atmosphere. And because every additional ton exacerbates that energy imbalance and those climate harms, we were able to prove that even Montana's emissions, which are actually quite significant, but this could be true for other governments too, they're exacerbating those climate injuries. And that's the burden that we need to meet. It's different. It's a different kind of causation standard or burden than in like a damages type case. So we didn't need to prove that the defendant's conduct is the sole cause of the injuries, but rather that it's contributing to and exacerbating. And it's similar for the redressability, that by having Montana reduce emissions, it will it'll help, it'll alleviate their injuries. So so that's what we were able to prove, and the court kind of understood that we didn't need to demonstrate there is no other source of that's contributing to their injuries as well.
And it probably helped that the state didn't really mount a defense to those issues.
Yeah.
It's also worth noting one of the other cases that we had a webinar about in Canada, the Mather case, poses a bit of a paradox in comparison to the Held case, because the court there accepted that climate change has a disproportionate impact on youth and on Indigenous peoples, but it held that the harm that they were suffering is caused by climate change itself. It's not caused by the government's actions. They had challenged specifically the government statute and target and plan for greenhouse gas emissions reductions. And the court said all that does is create a framework that's supposed to guide and direct decisions about authorizing emissions. It doesn't actually authorize or cause or contribute to those emissions. That's one of the issues that the claimants are trying to challenge on appeal.
Yeah, so I will admit I'm not as familiar with the landscape in Canada in that case, but in Montana, so there are a couple of different causation requirements, right? It's not just that Montana's emissions contribute to climate change, that's part of it. But I think what you're also bringing up here is that Montana's laws contribute to fossil fuel use and the greenhouse gas emissions that then contribute to climate change. So we did have quite a bit of testimony about how Montana really controls the state's energy system, how all of these fossil fuel activities would not be happening without permits from the state. And in Montana, we had some kind of egregious examples of laws that actually, explicitly promote fossil fuels. But yeah, I think you're right that you also need to show that there is state control and affirmative conduct that is promoting fossil fuels. And that wasn't too hard to show in Montana, and I think is probably true for a lot of other jurisdictions as well.
Thanks. So we'll continue with our questioners in the room, starting, why don't we go to the person in the black shirt first?
Hi there, thank you so much, Nate. The question's a little bit about prior to trial and the first steps of proceedings. So obviously this case is very novel in its strategy of using constitutional law, and also is a non-profit public interest firm going against the state government. What were the difficulties and barriers to that in even filing this lawsuit in the first place? How was it trying to get experts, trying to get plaintiffs? I just was wondering if you could speak to that a little bit.
Yeah. So I guess what I will say, at least in partial answer to that, is, Held was the first case that made it to trial, but it wasn't, we've been bringing these cases since 2010. And what happens, a lot of those cases, admittedly, were dismissed for various reasons. But what's unique about what we're able to do by working on all of these cases is each time we bring a case, we're learning from the previous cases, and we're improving proving how we bring the case and the claims and the evidence. So Held was really building on a lot of that prior work, including a lot of the work that we did in Juliana, which I think you're going to hear about more. So, it's true, we are still a pretty small nonprofit, and we have a nonprofit budget, so we're not a big law firm with unlimited resources. And a lot of times we're going up, against governments. Sometimes we get fossil fuel interveners. We didn't in Montana, but sometimes we do. And so one thing we do is we rely a lot on, like I said, experts who are donating their time pro bono. And it's actually not that hard to convince them to do it, because the type of experts that we work with, a lot of them, they're climate scientists, they're healthcare professionals. They have been working on these in this field of climate change and climate injuries for many of them for a long, long time. And they, I think, are excited about having the opportunity to bring their knowledge into a courtroom, because their research and writing and scholarship is all really, really important. And this is another opportunity for them to put their expertise towards a good cause and to really make a difference and see all their research and work over years kind of affect policy. So a lot of them are actually quite excited about the opportunity to do that. We also have, at this point, a lot of connections with different youth groups and youth networks. So, the plaintiff part, it does take quite a bit of time to end up with the right group of plaintiffs, because we have a pretty thorough onboarding process. It's a big deal to decide to sue your government. And as Claire mentioned, her parents weren't even supportive at first. So we really want to make sure that the plaintiffs know what they're getting into, make sure that they want to be plaintiffs themselves and that nobody is pressuring them to become a plaintiff. And so it does take time to do that and to do it right, and then to get to know the plaintiffs so we can tell their story, at least initially in the complaint. So it takes a lot of work. We also have a lot of volunteer partners, and so in the Montana case, we work with Montana Code Council at McGarvey Law and the Western Environmental Law Center, and they're also donating their time to the case. So it's a really big team actually behind these cases, and a lot of volunteer work. We have work with a lot of law students who help us out. So it's a team effort. And I will just say, I think one thing that helps us and sets us apart sometimes from who we're suing is, the passion and the energy that we bring to these cases, and the confidence that we're on the right side here, and believing in that what we're doing is the right and just thing to do. And so that helps us for some of those long hours and nights and weekends.
Well, I certainly believe that too, Nate. I'm going to go to a question here on the corner. If you could press wait till the red light comes on. Is it on? There it is. Okay.
Hi.
Hi.
Hello. I am from Ecuador, and it came to my attention that you said that you worked in about fisheries in Ecuador, and you did your thesis in that. Anyway, so with regards to like a court case like this, it's such an inspiring model of how to kind of, hopefully bring about justice if it's not too if it works out at the end. But so my question was in 2019, no, 2020, in 2020, well, there have been so many oil spills in the Amazon, in Ecuador, in the coast, in so many parts of the country, honestly. And there have been a lot of lawsuits too, like of indigenous peoples in the Amazon towards the government. And there have been occasions in which they have won and they have lost. And, I don't know if you're familiar with those cases, kind of, but like, what would you say are maybe ways in which they could make them, more successful? And how do you think, so I think one of the problems that the youth in Ecuador face to sue their government is first that there maybe is not built network like there is in the United States, or that much accessibility maybe to even education or to even know their rights as youth. So and like to contact professionals to form like a nonprofit like you have done to form youth networks. So how would you say the youth in Ecuador can like, you know, lift their complaints and basically realize their power and kind of you know, find justice for themselves too in a context of a country that is developing still.
Yeah. Yeah, that's a really, really great question, and I'm not sure I'm going to have a totally satisfactory answer. I spent a couple summers in Ecuador, although it's been a while, so I'm not familiar with the latest cases. But I think what you bring up is a really important point about accessibility to justice, especially for youth who are oftentimes, you know, they can't vote or, you know, don't have financial resources. And so I think, you know, education and awareness around the availability for anybody to bring, you know, lawsuits. You don't need to be, I mean, I should say I'm not an expert in Ecuadorian law, but generally speaking, it's my understanding, you know, you don't, anybody can bring lawsuits. I think having youth bring lawsuits is a really unique perspective that is important for courts to hear. And, you know, you don't always avoid kind of the political contentiousness of cases, but I think we try to. And as Claire talked about, you know, like this, we don't want these cases to be politically contentious. It's about protecting kids and future generations, and that's something that a lot of people can agree upon in principle. So yeah, I'm not sure about kind of the specific resources, but I think, you know, youth education is really important, and hopefully there are, you know, lawyers in Ecuador that would be willing to work with youth and protect their rights to a healthy environment. And I know there's a lot of challenges there with the oil spills and whatnot in the Amazon region. So yeah, those are a few thoughts.
Right. Yeah. I guess I just want to maybe bring up that it is honestly a privilege for youth to be able to claim their rights. It's honestly a privilege for youth to be able to form networks and have access to internet and laptops and phones and, you know, maybe in the United States in some parts it's just like it doesn't feel like it is that big of a deal to have an iPad, but it kind of is sometimes. So maybe I don't know. Maybe you can bring it up to like other like youth organizations in the U.S. and I guess you have a lot of contacts, but it's just like to realize their privileges as youth themselves and to realize that other youth that maybe, you know, needs clean water but doesn't have clean water because the river where they got their water is full of oil now, is facing bigger challenges and sometimes has less ways in which they can make their voices heard. So yeah, thank you for
Yeah.
yeah.
Yeah, that's a great point. And I think you know, another organization, it's not a youth organization, but it's a great organization that's also based in Eugene. It's called ELAW, Environmental Law Alliance Worldwide. And I know they've done some work in Ecuador in the past. And I do think, you know, it's important to have global solutions and to get so hopefully, you know, one way or another we can build on this success in health and elsewhere and support other countries as well.
Right. What was the name of the
It's
E-Law, Environmental Law
E-Law.
Alliance Worldwide,
yeah.
based in Oregon. Yeah, I think this challenge of spreading this global youth movement worldwide, especially outside the global north, is a challenge. But also I know that youth around the world are very active, and that includes in Latin America. I think we have time for one last question. Do you still have? Wait, hang on just a second, because there's one online. And you asked a question before, so let's give priority to the one online.
So another question from online. Rosa says, hello, thanks for the wonderful talk. I was just wondering why you think the state of Montana mounted such a weak defense.
Several people have, I actually get that question quite a bit, and I kind of like it because I think, you know, they really did mount a weak defense. And I think really what it comes down to is there is no defense. You know, how do you, especially when you have, you know, top climate scientists and experts in their field testifying, like, what defense is there? You know, climate change is happening. There's no scientific defense for that. And again, I think this underscores the importance of having these courses, or having these cases heard in a courtroom, because, you know, as we like to say sometimes, like, in a courtroom, facts still matter, and there's such a thing as perjury. So, and rules of evidence. So, you know, unfortunately, like, politicians and in the media, you know, like, they say all sorts of crazy things that are not true, but once you get into a courtroom, the truth still matters. And so there really is no defense or denying climate change. There's not even a justification for continuing to use fossil fuels. I mean, that's why we had that evidence about the feasibility of decarbonization. And that expert, Mark Jacobson at Stanford, he and his team have put together plans for every state and many countries, I think over 100 countries. So to show that they can all decarbonize, and not only are you meeting your current energy needs, but you're saving money, you're cleaning up the air. There's no reason to continue to rely on fossil fuels anymore. The economic arguments don't hold sway. The need for energy, we don't need fossil fuels. So I think that's why they fight so hard to keep these cases out of court. You know, the federal government in our Juliana case has been trying for 8 years to keep that case from going to trial. And I think the Montana trial kind of illustrates why in some ways, because it puts them on the spot and they have to take a position on the evidence, and that's hard for them to do. So that's my opinion.
Well, I think that is where we'll stop. Thanks so much for joining us, Nate, and for sharing your reflections about the case, its significance and experiences. So we will have one more of these sessions next week, and yes, Nate, you're right, we are going to hear about the Juliana case. So next week we're going to be joined by one of the plaintiffs and one of the lawyers in Juliana, which is another case that was brought by our Children's Trust. And so same time next week. In the meantime, though, just thanks so much again for joining us, and let's give Nate a round of applause. Have a good
Thank you for having me.
Bye.
Bye.